a very, very complex process to get it done to meet the testamentary requirements and to meet the record keeping requirements for that process. So we still have not seen that go into effect. So most people who are doing this will still be going into a physical location. And if you, for example, come into our office to do a will, you will see that we will also try to make sure that you have capacity. I will ask you a series of questions to make sure that you are of sound mind, that you know that who the president of the United States is. I'll ask you if you know that what date it is, what year it is, because you have to have capacity. If you no longer have capacity, you may have Alzheimer's, you have people who are suffering from dementia, you no longer have the capacity to enter into a legal document disposing of your assets. You know, that's important when it comes to this process, right? The next significant part is the probate process. Probate requires that the will be submitted to the court and that the court administer the will and appoint an executor who will have the authority to sign the documents necessary to transfer the assets. Because of that, probate becomes expensive, right? So let's look at the first scenario we have here. Dad and mom own a home titled as joint tenants with right of survivorship, or tenants by the entirety. This is a common situation in Florida. Anytime a married couple purchases a property in Florida, it is owned as joint tenants with right of survivorship. That is presumed under the law in Florida, unless there is a legal document stating otherwise, a prenuptial agreement or something, postnuptial agreement stating that. Dad has a will, and his will, Dad says he's leaving the house to his son. When Dad dies, who owns this house? Mom or son? And I'm going to open up and see if anyone wants to, Denise, you can tell me if anyone.
There are no questions, but if anyone has any questions, please.
If anyone wants to venture an answer to that in the chat room. If you want to tell me who you think owns the house.
So we have son, we have mom, the son. Anybody else want to guess on this? Oh.
Mom. Mom owns that house. Right? Mom automatically owns that house. That house never needed to be in the will because it doesn't pass by the will, right? It legally passes by the deed, even if it's in the will, right? It's not passing by the will. It passes by the fact that it's owned jointly with right of survivorship. So that's a legal document that passes. So upon Dad's death, mom automatically owns 100% of that house. There is nothing that Dad needs, mom needs Dad to do or Dad's estate to do to own the house. She can take Dad's death certificate down to the property appraisers or to the comptroller's office and get them to change the deed and put her name on it, even if she was not on the title. She doesn't need anything from the court to own that house, right? So that's how it works with that. So a will is designed to transfer property, title to property. So think of things that you would need to sign. Your signature is required to transfer to somebody else. Let's talk about your car. If you wanted to give your car to anyone, your son, your brother, if you wanted to give your car to yourself, who would sign the title to the car? Yes, if you put that in, you could put it in the will, and it would have to pass, it would have to go through probate, right? But it doesn't have to necessarily, right? Anywhere there is a gap in title, probate would be required. Who is going to questions you have to ask is, who is going to sign the transfer deed? And that is where probate will come into the process. And that's what goes into a will. I don't like probate property. In my estate planning for my clients, I try to limit probate property as much as possible because probate is expensive. It's very, very expensive. And the primary reason probate is expensive is this: attorney's fees. You cannot do a probate estate without hiring an attorney. You can't do it pro se on your own. You must have an attorney to do it, right? No self-help, no pro se process, right? And if you have significant assets, for example, a home, you're going to also have other things involved in there, appraisers' fees involved, right? Fortunately, you know, we don't have gift taxes or estate taxes and those things in Florida. And fortunately for most people, the gift tax and the estate tax has gone up in 2020 for an individual estate. It's currently 11.58 million. That's the exemption amount. So if your estate is less than 11.58 million, you're not paying any estate tax or death tax.
Sasha?
Yes?
We have Lydian who wants to ask a question. Lydian, I see your hand is raised. Can you please put your question in the Q&A box, and we'll have Attorney Watson answer your question.
Because I was about to say, I don't see any questions. I have my Q&A box open.
I'm sorry for interrupting. You could
No
continue.
problem. Right? For most people, okay, one moment. I'll answer that question. I see your question. That's John. The name is John, so I'll use the name that I see here. I'm going to answer your question, John. So, and I'll just finish the point about the costs. So for one of the major costs of the probate estate, like I said, is the attorney's fees. On average in Florida, attorney's fees will be 3 to 5% of the value of the estate, right? So that's a major cost that will have to be paid from the value of the estate. So I was just reading. So John asked if for a homestead exemption, if a home is purchased by two people prior to marriage, does the deed need to be revised? And John, you're going to have to give me more clarification on what you're referring to. Does the deed need to be revised for what purpose? You can type what you're trying to get to. Does a deed need to be revised for what? Do you want it to be passed to your spouse? I'm not sure what you're referring to there. Okay? All right. So let's go back and talk about more about probate. The other part about probate is that it's also not a quick process. It's public. Probate can take 6 to 9 months. It could be longer than that. You know, we have significant backlog in our court systems, so it can be a long process. The other thing is that if you own multiple pieces of real property, that is real estate, land, homes in different states, you may have to probate your estate in different states, and that can be very expensive. That's hiring different attorneys in different states, and having that estate probated in multiple locations. So that can also get complicated and expensive. The other part is that probate can also doesn't address the issues that arise upon incapacity. And we'll talk about incapacity and disability some more as we get further on in the presentation. So if you will your home to your daughter, the house is valued at about $200,000. You own it free and clear. There's no mortgage on it. What would be the average cost to administer your estate? And we have here that the average cost is going to run you about $11,000, right? And I'm going to kind of break down what we're talking about here for that average cost. We're looking at 3 to 5% for the attorney's fees alone. We're looking at the appraisal fees as well, court costs. It's going to be in that. So it could be quite costly. And if, for example, let's say your child does not have that upfront money, a lot of people end up having to sell the home that you are planning to transfer to that child in order just to pay off that $11,000 of costs. So it does take some, sophisticated planning to make sure that the asset that you want to transfer does not have to get sold just to finance the transfer process itself, right?
And Sasha, you have some questions in the Q&A?
I see the question. So for the homestead exemption to be passed to the spouse. Okay, so for a homestead exemption, if a home is to be purchased by two people prior to the marriage, does the deed need to be revised for the exemption to be passed to the spouse? Okay, so John, for the homestead exemption, for example, if you were to pass, if you were to pass and you and your spouse would, for example, if you did not have the intention of passing that house on to your spouse, let's say it was not your intention for your spouse to have that house, is that what you're saying? You just want her to live in the house? Because your spouse would, for example, be entitled to at least a life estate in the house under Florida law. And yes, she would probably still be entitled to the homestead exemption for the duration of her life. And I'm reading the questions here.
I think John said he wants the exemption to go to his spouse.
Right. So the exemption would go to the spouse. So if you wanted the house, let me ask you, do you want the house itself to also pass to your spouse, or just the exemption? Who is the house going to? I have another question. So John clarified that. If an unmarried couple purchases a home together, is it automatically joint tenants with right of survivorship if no other plan is put in place? No. If an unmarried couple purchases a home together, they're considered tenants in common, right? And typically, they're unless they specifically put in there the percentages, the Florida defaults to a 50-50 tenants in common, right? And let's say, for example, one party wants to get out of it, they would have to petition the court to partition for a sale of the property in order to get their 50% share out of the property. So it's not an automatic joint tenants. That only applies to couples who purchase a property while they are married. Okay? All right, let me move on to the next slide.
Oh, Sasha, you have another question from Faith about will lien on the property. Do you see that one?
Can you will a lien on a property? I'm not sure. So you're saying if you have, for example, a judgment and that judgment, it forms a lien, can you will your entitlement to that judgment or to that debt? I'm not sure. I don't want to mislead you on that. I'm not entirely sure on your obligation to collect that debt while you are alive. You're going to have to let me research that one, and I'll send that response to Denise to pass along a response to you on that one. I'll make a note on that.
You have a couple more questions.
Okay. Hold on. Tell me which question I missed.
How do you add someone to your deed, such as an adult child?
Okay, so you can add someone to your deed by doing a quitclaim deed. If you wanted to add someone to your deed, you can do a quitclaim deed to add them. If it's really just adding their name to the deed. And that's usually the quickest way without incurring any additional costs.
And John, I think Attorney Watson wanted some more clarifying information. So
yes,
if you can add that to the, oh, he did just add some information. So
my question for John is do you want to pass the house on to your wife? Is that what you'd like to do? So that in the event you pass away, she would inherit the home. You can give me that response, and then I'll come back and answer that question. So let's talk about probate property versus non-probate property in the meantime.
You said yes.
Yes, so perfect. So yeah, in the event that you wanted your wife to inherit the property, the best thing to do would be to also do a quitclaim deed from yourself to yourself and your wife as joint tenants with right of survivorship. And it would then accomplish that. So should you or your wife pass away, subsequent to that, the other party would own the property outright.
Then you have another question. What is JTWROS?
Joint tenants with right of survivorship.
Thank you.
All right.
Yep, that's all the questions. You answer all of them.
Okay.
Thank
so
you.
Probate property versus non-probate property, right? So non-probate property goes straight to your beneficiaries and avoid the probate assets. And this is truly the ideal position that you want to be in. So these are joint tenancy, co-ownership, assets. So this is the joint tenancy with right of survivorship, just as we do with our property, for example, with your home that couples own. If you're married in Florida, the law automatically does that for spouses so that you don't have to put your house through the probate process if you are a couple. Florida law automatically does that for you, right? If you jointly own a bank account with someone and that person dies, you don't have to put that bank account into your will and go through probate. The other person on that bank account automatically owns everything in that bank account because it technically is owned as joint tenants with right of survivorship. You own it 100%. So that's one way, right? For example, the other things that are not non-probate assets, things that have specific beneficiary designations, life insurance, right? Your pensions, because you designate a beneficiary. You can also do that with your bank accounts. You can go to your bank. Let's say you don't want to have a joint bank account with someone. You can go to your bank and tell your bank, fill out the required forms at your bank and say, I want to designate a payable on death beneficiary for this bank account. So in the event that I die, my beneficiary can come in to the bank, present my death certificate, and obtain the funds in this bank account without having to go through the probate process, right? Saves them having to pay those attorney's fees and having to go through 6 to 9 months of a court process, right? That is ideal. There's no signature requirement for transfer of the assets to you because guess what? While you were alive, you've already done the signature process to transfer it to the designated beneficiary. So these are what we call non-probate property. There is nothing required from you, right? That's the ideal position that you want to be. Trust is also a non-probate property because the trust already has an instrument with instructions and a designated person to do all the signatures required for the transfer. There will be a trustee.
I'm sorry, everyone. She must be having technical difficulties. Um, this is Denise Smalls again. So I'm sure she will dial back in a few minutes. Thank you for, I thought it was just my connection. There she go.
Oh, I think we just lost internet's connection for a second. Are you seeing my screen?
I do see your screen.
My slideshow is still there?
No, I just see you.
Okay, so let me get that slideshow back on. No, wrong one. Hold on. Okay, here we go. You seen it now?
Yes.
All right. Okay, so let me move on before we just recap on the wills, right? So a will is still an important instrument to have just because you never know what may happen, right, to you. But it is not the ideal instrument to pass your most valuable assets, your large, your big ticket items, such as your home, your expensive vehicles and things like that. it is good to pass family heirlooms that don't necessarily have significant dollar values but have more sentimental value. And it's also good to put in there a catch-all, a residual clause that says, in the event I may inherit something from somebody that I don't know about, or God forbid I die in a car accident and there's a judgment that gives me a whole bunch of money, I want it to go to X, Y, or Z. But all my bigger items are going to get passed on some other way. My bank accounts, my retirement accounts, my investment accounts, all of that is going to pass automatically on my death some other way. The bank accounts will have payable on death forms. My home will be properly titled so that it will either pass to my spouse or my kids, or it will be in a trust and properly disposed of otherwise. That's the ideal component for those bigger items. The will is not the way to dispose of those assets, but it is still an important item provided it is done correctly, right? Trust. Let's talk about the trust, because this is something a lot of people talk about and they inquire about more frequently these days because everyone wants to be a trust fund baby. And a trust is really just a legal construct. What it means, it's a legal instrument that an attorney will draw up. It doesn't really mean much in terms of your assets. It's hard. It's not something that's necessarily tangible by itself. It's hard to put into words because by itself it means nothing, right? But once it's drawn up and it has your instructions in there, what you next will do is what we call funding the trust. And let's talk about the different components. It's very similar to a will in that it will have all the components of a will, in that it will dispose of your assets, it will have instructions of your assets, but it goes a step further because it can make allowances not just for death, but it also can talk about incapacity and disability as well. So it is definitely more flexible and versatile than a will. And it's also a better document because it is 100% private. No one has to know about your trust. It does not go through the court system, and it is not a public document. So the grantor or settler of the document is the owner of the trust. And if you are the person doing a trust, that would be you. The trustee is the manager of the trust, and while you're alive, that can also be you. The beneficiary of the trust is the person who will benefit from the trust, and while you are alive, that can also be you. And the remainder beneficiary is going to be the person who inherits from the trust and gets the assets from the trust when you die, and that's going to be traditionally your children or your children's children or your friends, your loved ones, charities, and so on, who you intend to obtain your assets upon your death. There are several different types of trust. It's part of the flexibility of this type of document. One of the things about trust is that it's definitely flexible. We'll talk about revocable living trust because it's the most common type in terms of it allows you to do all the things that you want it to do in terms of what we're talking about here, in terms of protecting your assets. It allows you to change it while you're alive. It allows it to be private. it disposes of your assets, it protects you in terms of disability and incapacity, and you can make changes to it. And that's why it's called revocable. You have spendthrift trust, which can limit your heir's ability to inherit. If, for example, you don't want your children to inherit if they are not responsible with their resources. That's why it's called spendthrift, meaning you can cut them off, or you can limit how they inherit. Special needs trust, meaning a lot of people may have Medicaid issues and therefore, or disability issues and Medicaid planning or tax planning issues that go into that, and disability planning issues, and there are different types of trust that will be designed to deal with those types of issues. We'll be dealing with the revocable living trust because it's the most common, and really these types of trusts do not require any kind of sophisticated tax planning issues. You will file your regular tax instruments, you will report these on your taxes as regular. Your accountants will be familiar with them. You don't have to do any kind of special tax reporting or tax filing for these types of trusts. So you will be the grantor. You will place assets in the trust, and by placing assets in the trust, meaning that you will title your assets in the name of the trust. So for example, I can have a trust document. I go to my attorney, I will have them prepare the Sasha Watson Sankey Revocable Living Trust. Then once I have that trust document in place, written and drafted, I go to the bank and I say to the bank, I'm going to rename my bank account in the name of my trust. And so my bank account now becomes the Sasha Watson Sankey Revocable Living Trust account. And that's how I fund my trust. My home that I live in will now be titled in the name of my trust. And that's how it also gets funded. That's how the trust becomes funded, right? And then upon my death, it's already titled in the name of the trust, and everything will be disposed of in accordance with the instructions that are in that trust document that was drafted by my attorney and amended by me over the years, right? The document is still going to have the same testamentary requirements as my will. Has to be signed by me in the presence of 2 witnesses, and also notarized by a notary in the presence of me and those 2 witnesses as well. That is still required. But I also have the ability to do a lot of more sophisticated things in terms of how my assets are distributed in terms of the trust document. And of course, it's 100% private, because I have already, through that trust document, given authority to my trustee legally to do all the transfer required to transfer the assets, right? And really what it is that let's say, for example, I am the initial trustee of the trust. Upon my death, I have already instructed who will be the new trustee of the trust, and that person can then has the authority to sign all the documents necessary to transfer any assets on my behalf. They're called inter vivos trust, is another name. Any questions? Am I missing any questions here, Denise?
Nope. No one has posted any questions. Please remember, if you have any questions as we go along, please add them to the Q&A feature.
I'm just making sure that I'm not missing anything here. All right. So it's one of the most effective estate planning tools for simple to moderate estates. It can hold basically any type of assets that you can think of can be placed into a trust. It's definitely a lot more expensive to establish a trust on the front end than it is on the back end, right? A will is a lot cheaper to establish. Probably on the front end, it's probably going to cost you $250 to $500 to do a will. It may cost you $2,500 to $3,000 to do a trust. However, it's gonna be much cheaper on the back end you're gonna recover those costs on the back end with a trust upon your death. Because with a trust, there are no costs. The transfer is automatic with a trust. However, with a will, you're gonna go through the probate. And of course, most people will say your assets at the time you die, especially if you have real estate, will cost you way more than, for example, than your present value of your estate is going to be way less than the future value of your estate, right? Of course, non-trust assets will be your 401k, your IRA accounts, because you already have designated beneficiaries, just as well as your life insurance, of course, because you already have those designated beneficiaries. I also will say, do not put your cars in your trust. Do not title them in your trust, because you will find that it will become very, very difficult for you to obtain car insurance. It will also become, you will also find yourself the target of a major lawsuit in the event that you meet into a car accident, because it will seem that you have very deep pocket if you meet into a car accident and someone sees that the car is owned by the trust of X, Y, and Z, right? Because like I said, everyone wants to know that they have such and such trust fund. So I don't encourage having your car in the name of your trust. But if you're concerned about transferring your car, let's say you have a car that you don't intend to sell at any point, and you have it and you want to dispose of it, and you have the title, you know who you want to give it to, and you're not concerned about any fraud or anyone cheating any of your relatives, I can tell you what I do. I have my title. My title is in my document safe, and I sign it. My title is signed, and it's there with instructions attached to it. And so if I, for example, untimely pass away, someone can go down to the DMV and transfer it to who I've instructed it to be transferred to, because it's already signed. And that's the easiest way. It still doesn't have to go through probate. That's not necessarily legal advice. That's just practical advice with respect to transferring a car, right? Your revocable living trust can also have an incapacity clause, but you can also have a durable power of attorney that can also take care of an incapacity clause. And let's talk about this. My preference as far as an incapacity clause or in your trust versus your durable power of attorney is that in the event that you are incapacitated and you need someone to handle your affairs, you don't necessarily want the person handling your affairs to take your entire trust document to the bank or to the power company and to have them review the entire document to find out that Mary has the authority to conduct whatever business they're conducting in order just to conduct that business. You don't want them to necessarily know all your business just for Mary to be able to turn the power on or off, or to make changes to an account or whatever she needs to do. So yes, you can have the incapacity clause there as as it would be duplicative, but I still recommend having a power of attorney document separate and apart from your trust document, right? The revocable living trust is definitely more ideal than just having a will, because in the long term, although it is more costly to establish on the front end, it is definitely cheaper than having to have your assets go through the probate process.
Sasha, you have a question?
Hold on, let me see. I think I've lost my screen here when this shut down. Can you tell me what the question is? I'm trying to reopen.
Yes, it says, is it better to have a durable power of attorney or general power of attorney?
Okay, so a durable power of attorney, the durable part of it just means it is continuing without a specific termination date, and it's durable for, like I said, without a specific termination date. There will be a termination based on a specific event, so to speak. So, for example, if you are incapacitated, upon you no longer being incapacitated by the determination of a doctor, that durable power of attorney will cease to continue. Or, for example, it will be durable until you no longer desire it. For example, if it's not an incapacity issue, right? A general power of attorney is not. It's basically the term of art is really just durable. There's the general. There's no distinction between general and durable. You understand? And I'm trying to pull my screen up. Let me see if I can get it back. Here we go. It's a chat or the Q&A? There we go.
It's the Q&A.
There we go. Right. So there's not necessarily a difference between a durable or a general power of attorney. Each document will delineate the different powers in the document. Durable just has, it really talks to the term length of the actual powers involved. Okay? So time frame for transferring assets under revocable living trust is typically 4 to 8 weeks, provided that you are actually going to transfer. Most people with revocable living trust, your beneficiaries will probably just take over the trust itself, not necessarily take over the asset and turn over the assets to their name. They usually just turn over the trust document and make amendments to the trust. Like I said, you avoid the expenses of probate. It's the same taxation process, same tax returns. You can, because the estate tax system, the estate, not the estate taxes, but the gift taxes and the estate taxes have gone up so much. For 2020 is, like I said, 11.58 million. For the average American, you're not paying any estate taxes. Most people don't have to worry about that. When I started doing that, it was more of a concern because it was 500,000. So in the last 10 years, we have gone from 500,000 to $11.5 million. So that is less of a concern these days for most people, for the average American family. one of the misconceptions is that if you have a revocable living trust, that your assets are going to be protected from creditors. That is absolutely not true. You're not shielding your assets from creditors in any shape or form as if you did not have a trust. That possibly could be achieved, but in a different type of trust. If your trust was irrevocable, meaning that it's a trust that you no longer had control over, that you no longer could touch, that you no longer could access yourself, or that you no longer, could make changes to, you can't get to those assets, possibly. But most people don't want to put their assets in that position. So that doesn't apply to most of us in our daily lives. For some people, that's a possibility. But in revocable living trust, you have control over the trust. You manage the trust. You are the trustee. You continue to manage the asset. You do everything for this trust, and therefore your creditors can still reach and attach to the assets of this trust, just as if those assets were still in your name and not in the name of the trust. You cannot do a will until you reach, a will is not valid until you reach the age of 18. That was Faith's question. At what age should you suggest doing a will? You have to be 18 under Florida law for a will to be valid. And then you said, or should a will be established according to your assets? I suggest that anyone over the age of 18 should have a will, just because, like I said, just because you never know what could be the circumstances of your death. You should still have a will that at least gives some instructions as to the residual, where your assets should go in the event you happen to have some assets, right? But ideally, if as you obtain an asset, right? So I want you to understand, as you obtain assets and as you go about obtaining assets in your life, as you obtain the asset and you put it in your name, you also are making allowances for disposing of the assets at the same time you are putting in your name, if that makes any sense. So for example, let's say you acquire your home, you should be consciously, as you purchase the home, you are titling the home, so that once you title the home in your name, you are also titling it so that if you die the next day, it passes on to whomever you want it to go to. So that's why Florida law is written that way for couples who are married. Automatically, if you are a married couple and you purchase the home today, it automatically goes to your spouse if you die tomorrow, right? So let's say, for example, you purchase a car or something else, and you want it to go to whoever else you want it to go to. You can make allowances to do that. If you go and open a bank account, and you know for a fact that if I die, I want to make sure that the money in my bank account goes to my mom, you open the bank account. You say to the bank, you say to the representative at the bank, I want to fill out a payable on debt form at the bank. So you open the bank, you sign the forms at the bank to open the account. You, at the same time, you sign the payable on debt form. So you do, as you acquire the asset, you make provision for disposing of the asset at the same time. That is ideally the best way to do this. Right? Any other questions?
Nope, I don't see any questions.
Right?
And Sasha, I just wanted to let you know it's 7:45. I know we started late.
Oh, well, I know I talk a little bit. Occupational hazard. All right, so you create a trust and you leave the 200,000, same $200,000 home that we talked about, and you want to leave it to your daughter. What is the average cost to administer the estate? And now we're looking at about $1,900. And the cost that we're talking about here in the $1,900, we're talking about the documentary stamp tax of transferring, doing of the stamp tax of doing a new deed, putting that property in your daughter's name, the cost for an attorney to prepare that new deed, is what we're looking at in terms of the cost there. That's what we're looking at. $1,900 is what that new cost would be of transferring that home, right? But of course, you did prepare. Remember, you also did spend maybe, like I said, $2,500 some years earlier in preparing the trust. But it's the overall cost of a trust tends to be significantly less than if you were to do a will, because overall it's not a percentage cost as that comes with the probate process, right? And I'll try to move a little bit faster. I don't want to keep everybody. A living will, right? Anybody remember the Terry Schiavo case? This was a huge case in Florida. The debate on whether or not to keep her on artificial means. She was on a feeding tube for a long time. I believe it was her parents versus the husband on whether to keep her on these life sustaining mechanisms, right? Living will. The primary thing about a living will, as an attorney, I always say you need to discuss a living will with your primary care physician first and foremost to discuss what does artificial extension of life mean from a medical perspective, not just a legal perspective. What does it mean? Provides directions for your healthcare if you are incapacitated. And the problem with living wills, and what I have been told medically, is that for most people that do living wills, is that medical technology advances so fast that at the time you do a living will, the medical technology that exists at the time when you do a living will does not exist at the time when your living will is activated, and therefore the doctor does not want to abide by what you said you wanted in your living will. So therefore, you can't just have a living will by itself that says, I don't want to be resuscitated, I don't want to be on artificial extension of life. You also will need a power of attorney or a healthcare designee to say she does not want to do this. You need to have somebody with the authority to speak on your behalf. Those two things will have to go hand in hand in order to put that power into effect. And so so I always say we put those two, and I do a combo document for that to make sure my client's power is, wishes are actually going into effect, because that is a major issue we see today in the healthcare system. So durable power of attorney, this type of document was recently changed in Florida because there was a lot of abuses in the power of attorney arena. So Florida put more stringent controls in there. People would just go and get a power of attorney and go in and do all these legally take legal actions with people affairs, whether it's transfer property, going to their accounts, and all these things. And a lot of banks would say, we don't take power of attorneys off the road. You have to sign the account holder has to execute our power of attorney document in order for us to take any action with their accounts. So that used to be an issue. But Florida has recently changed that within the last couple of years. So the documents are very different with their attorneys. but you want to pay attention if you are executing a power of attorney document, because it does give people a lot of power, you know, and you want to make sure you are paying attention to the powers that you are giving under a power of attorney instrument, because you can give someone the power to change your will, for example. You can give power of attorney to transfer your property, such as your real estate, not just to sign documents, you know, on your behalf, but extreme powers as well. It does require the same testamentary requirements as the execution of a will, 2 witnesses and a notary. You're giving them power to speak on your behalf, to take action, the same action that you would have. And then you can also give somebody the same power over your health care in the event that you cannot speak on your own. Any questions? I know I sped through the power of attorney portion. Any additional questions here? Okay, let's wrap up. So required documents, pourable will, still required document, but not ideal to put everything that you own. Only thing that we're putting in there, we're gonna put all our sorority items, or you know, or jewelry or crockery or stuff like that, but we're gonna transfer the house, we're gonna transfer our retirement accounts, our bank accounts, and all our other things some other way. All our big ticket items we are not going to transfer through our will. We're going to figure those things out separately. And if we can put them payable through, if we can do it through a payable on death, or we can put designated beneficiaries, we're going to figure that out and do it that way. The ideal goal in our estate plan is to be able to die completely broke. At the time we die, we do not own anything. We have already transferred everything. Upon the moment we take our last breath, everything that we own has automatically been transferred at the moment we take our last breath. That is the ideal goal. A revocable living trust is definitely a good type of instrument to transfer that. We want to incorporate an incapacity clause, but we also want to also have a durable power of attorney document, just so that we don't have to necessarily expose all our estate planning tools through our revocable living trust. Want to have a living will, but it's definitely something that we need to discuss with our medical providers to make sure that we fully understand the medical implications of those terms and those life-sustaining medical instruments. We need to make sure we are clear on that. We want to have a power of attorney for our healthcare, because we need to have an advocate in the hospital room, in the nursing home facility, to speak up on our behalf, to make sure that our desires are also being spoken up for. The living will, the instrument itself, does not speak for itself, so we have to have that spelled out as well, and we also have to have that communicated. One of the most important things that we need to do, and I did not discuss it earlier, to avoid chaos, you know, because a lot of times what I get, you know, on the back end of this with families is absolute family turmoil. You know, we see it in our communities where, you know, when family members pass away, is that siblings, children tend to feud between each other. And part of that feud is as a result of us not being clear to communicate what our desires are to those family members in terms of how we want to dispose of our assets. So like I started out this webinar discussing, estate planning is not necessarily just an issue about death, which is a topic that we don't like to discuss. It really is a family planning issue. And as a family planning issue, it has to be discussed with the family. So once you have determined how you want to dispose of your assets, you need to discuss it with your heirs of how you want to dispose of these assets, so that it is clear what your intentions are. Same thing with your desires in your living will. If it is that you do not want to be resuscitated, and you know what you want to do, you need to discuss it with your heirs. When you are selecting who you want to appoint as your healthcare surrogate or power of attorney, you might not be able to pick your spouse. You might not be able to pick the child who's closest to you, because that may not be the child who is going to be able to pull the trigger or to be able to take you off life support, which is your desire. You may have to pick a church member or somebody who is not necessarily within the four walls of your house, because the people within your house may not have the physical strength necessary to make the decisions. And if that is what you may have to do, you can't not discuss it with them while you are in good health. You have to discuss those issues with your family members while you're in good health, so that when the 11th hour is upon them, that your family doesn't descend into turmoil, because your wishes were clear and the wishes were expressed to them from your own mouth. So that is important, right? It's important to get your estate plan in order today. And I always say to think about this consciously as you go about your daily life. Like I've stressed throughout this process, as you are acquiring your assets every single day, as you are making plans, you should be also making plans to dispose of those assets. Take an inventory of your assets. You can consult with us. You know, we are local here in Orlando. We offer free consultations. We're not open yet. We go back into office on June 1st with modified office consultations. You can call us for a free consult, of course. Our contact information will be available. I will email over, Denise, I'm not sure if we email that to you, the action plan checklist that we can email out to the attendees, so that you can take an inventory of your assets and you can get started on the checklist. I encourage everyone over the next week, or when you can get into your local banks, to go into your bank as soon as you can and to get your own payable on death form lodged with your bank. It's not going to take you long to get into your bank. Every bank has those forms already in the bank. You go in there, you don't have to list one person. You can list 10, 20 people. You can put 10%, 5%, 2%, however you want the amount split up between your family members. And all those individuals have to do, present death certificate, present an ID of who they are, and the bank will distribute the amounts to them. Same thing, you can do that with life insurance, pension plans. All those things can be distributed, and that can be done quite easily without having to go through a will or a probate. I have a few minutes. I know we're getting up until the 8 o'clock hour. 5 minutes more. Anybody else have any questions?
There's one last question from Cheryl. She said, what is it called again?
A payable on death form.
And in terms of the checklist, once Sasha sends it to me, then yes, I will send it out to all of you guys. Sasha, is that it, or is there anything else you wanted to discuss? Is that it? Okay.
No, that's it.
Are there any more questions for Sasha before we wrap this up? Thank you, Sasha. You did an excellent job. We appreciate all the great information.